Driving while intoxicated, or DWI, is driving a motor vehicle in a public place while intoxicated. Now, intoxicated doesn't mean drunk. Intoxicated means that you've either lost your normal physical or mental faculties, or your blood alcohol content is above a 0.08. This can be shown in a myriad of ways. For instance, how you walk, how you talk, or, as some people might have seen recently on TV, having your blood drawn or even blowing into a machine that might tell you what your blood alcohol content really is. Many folks, when they're pulled over on the side of the road under the suspicion of a DWI, or driving while intoxicated, think, gosh, I'm screwed. If this cop is coming up to me and asking me these questions about me drinking, I'm automatically going to jail. I have to cooperate with everything that this officer says. One of the things that most people don't understand is that DWI is more of an opinion crime. For instance, if an officer smells alcohol, sees glassy eyes, or hears slurred speech, that's his opinion. He doesn't know you from Adam. He doesn't know your normal day activities, what you do when you're out on the town, how you act or react to weather, or, for instance, allergies that you may have. All of these things are a totality of the circumstances when it comes to determining whether or not an individual is intoxicated. And simply observing one or two clues does not mean you are legally intoxicated. The rights that you have when an officer pulls you over include the right to remain silent. You don't have to perform these tests. Now, I'm not saying that you shouldn't, but if you find that, for instance, if you have medical issues, you should make these things known to the officers. And obviously, your Fifth and Sixth Amendment rights under the Constitution preclude them from taking evidence from you without a warrant. This includes you speaking to them, answering their questions, or doing any of the tests that they may want you to do. Again, what they observe in these tests are their opinions to make a determination whether somebody is intoxicated. The only people that get to make the determination of whether you're intoxicated is a jury of your peers. A lot of folks ask me whether or not they should blow if they're accused of a DWI. And by blow, I mean blowing into a machine that may determine the blood alcohol content that's inside your system. One of the reasons we talk to folks about whether or not they should participate in these tests is the fact that this is not necessarily a science. The art form behind investigative techniques in police departments all across the nation include the statements taken before and after a breath test. It also includes a myriad of expertise, classes, techniques that are deployed when an officer is attempting to take a breath sample from you. Most of the officers in Texas aren't trained well enough to operate these devices. This decision obviously is up to the individual person. I would never want to tell somebody what to do in that moment. It's their determination to make. But there are collateral consequences if you decide not to participate. For instance, if you don't give a sample of your breath or blood, your license could be suspended for up to 180 days. Getting pulled over, arrested, and sent to jail for a night is just the start of a long road if you're accused of a DWI. If you're brought to court, a judge could order that you not drive or install a device in your car for a long time. Even before that, the magistrate or the judge that hears whether or not there's probable cause for your arrest could make an assortment of conditions of your bail before you even step foot into a courtroom. For instance, putting an ignition interlock device in your car or a personal alcohol monitoring device on your ankle or person could be a condition of your bail for up to as long as 3 years while you're waiting for the determination of your case. The punishment ranges for DWI vary. If it's your first offense and your alcohol content, if you gave a sample, is below a 0.15, the range of punishment is up to 180 days in jail and a fine not to exceed $2,000. If it's your DWI second, or if it's your first DWI but you gave a sample and that sample is above a 0.15, the range of punishment is not to exceed 1 year in jail or a fine of $4,000. This doesn't mean that every single person is going to go to jail. There are a lot of options that a prosecutor and defense attorney can talk about as a resolution for a DWI. For instance, you could be put on a standard probation. That probation could be a term of up to 2 years. Most of the time they have conditions, classes, if you will, talking about drug use or DWI and the dangers that driving while intoxicated presents to the public at large, which it does. And that's an important consideration if and when you make that determination to get behind the wheel. One of the things that prosecutors harp the most to us is driver safety. And I think that has been in their lexicon for many years because of Mothers Against Drunk Driving. Mothers Against Drunk Driving has been around for a long time and advocated for strict penalties for DWI. So when you're facing a DWI consequence, classes, fines, fees, responsibilities for your car, your license, all these things are collateral consequences most people don't think about. DWI is often an opinion crime. An officer who sees red glassy eyes, hears slurred speech, or smells the odor of alcohol can arrest you on the scene. Someone who's never met you before, never seen you walk, hear you talk, knows of your medical allergies, or knows how much you drink, or if you drank at all that day, can take away your freedom. A DWI arrest, a conviction, or even a dismissal can change your life. It can be the difference of getting a job, being evicted from your home, or continued employment in what you have today.